Rules and theory of criminal law. Let's start with the definition. Now, criminal law in a nutshell is the branch of the legal system that decides what counts as unacceptable behaviour in society. It is the ultimate referee blowing the whistle when someone crosses the line. But it doesn't just say, oh, you can't do that. It also spells out what happens if you do, and how the whole process works when you're called up in court before a judge. So it lays out the rules, but also the punishments and the procedures that for bringing alleged offenders to justice. Now, a cornerstone of criminal law is that a crime has to be made up of two main ingredients, a little bit like a legal Victoria sponge. The first of these ingredients or elements is the actus reus. This refers to the guilty act itself, the actual deed that's against the law. You cannot be convicted for just thinking about committing a crime. Otherwise, we'd all be in trouble. The second element is the mens rea, or the guilty mind. This is all about intention or recklessness. So basically, did you mean to do it, or were you just very careless? Now, for something to be classed as a crime, you need both of those things. You need both the actus reus and the mens rea. They usually both need to be present. There are some exceptions, some rare strict liability offences where intention doesn't matter. And also a crime must be punishable by the state and not just frowned upon, in social circles. Let's move on to the purpose of criminal law. Right, well, firstly, deterrence. The law aims to act as a great big flashing don't do this sign. Don't discouraging people from committing offences. That's a really big part of the purpose of criminal law. Harsh sentences can be a warning to society, although, let's face it, lots of people just don't pay attention. And of course, when alcohol or drugs are involved, they really don't pay attention. Another purpose of criminal law is retribution. So this is the classic eye for an eye situation or business, making sure those who do wrong get what's coming to them. So it's a bit like karma, but with a lot more paperwork. Next, we have rehabilitation. So the law isn't just about punishments. There should be a bit of a softer side too. And this is where rehabilitation focuses on helping offenders get back on track, perhaps through community service, education, therapy, because everyone does deserve a second chance. Next, we have public protection. So keeping society safe by removing dangerous people from the streets. And this is usually by sending them to prison. And then finally, we have vindication of the law. So part of the purpose of criminal law is to reaffirm society's values and moral boundaries. When the state steps in and enforces the law, it's making it really clear that certain behaviour just won't be tolerated. You can see there drink driving laws, for example. Think of it as the legal system wagging its finger at, the naughty people of society. Let's move on to evaluation. Now, in terms of criticism, some people say that deterrence isn't all it's cracked up to be, especially for impulsive crimes like assault or theft. After all, most people just don't stop, do they, to consider sentencing guidelines before they, steal a car or nick a chocolate bar. It can be quite impulsive. And then we have a reform idea here. Maybe also we should be focusing more on rehabilitation. And this would mean fewer repeat offenders and a happier, safer society. Plus, it's cheaper, isn't it, than building more prisons as well. And finally, let's just consider this AO3 link. There's a constant tug of war between justice for victims and reform for offenders. It's a bit like arguing over, what ingredients we should have on the pizza. Okay. A good example actually would be, say, sentencing policies here as well. So, whenever a serious crime grabs headlines, like knife crime, for example, politicians tend to review and toughen up, don't they, on sentencing policies, sort of saying, don't worry, we're on the case, and reassure the public justice will be done. It's also supposed to scare off would-be offenders, although whether that works is another matter entirely. Now let's move on now to the burden and standard of proof. Okay, so what's the difference between them? Well, first of all, burden of proof. So in criminal law, the prosecution, sometimes called the Crown, it's their job to prove the defendant's guilt. The defence doesn't have to prove innocence. All they need to do is poke enough holes in the prosecution's case to create reasonable doubt. Or sometimes they may need to prove exceptions like insanity or self-defence. Then we have standard of proof. The prosecution must prove guilt beyond reasonable doubt. In plain English, this means so that you are sure. Now, this is a much tougher standard than you would get in, say, a civil case. Now, in a civil case, you only require proof on the balance of probabilities. But obviously for crimes where people may go to prison, that standard of proof has to be much higher, doesn't it? Now we have a key case here of Wilmington versus the Director of Public Prosecutions. This famous case set out the golden rule, as we call it, or the golden thread of criminal law. It is the duty of the prosecution to prove the prisoner's guilt. This is called the golden thread. It runs through all criminal trials and it makes sure people are innocent until proven guilty, which is reassuring, isn't it? Especially if you've been wrongly accused, for example. Now, in terms of evaluation, one big criticism is that it's a very high standard, isn't it? This beyond reasonable doubt. And that's good because it will protect innocent people. But does that sometimes mean that guilty people walk free? It's a bit of a classic dilemma. Is it better that 10 guilty people go free than one innocent person is punished? And then let's consider a reform idea as well. So some folks want a lower standard for less serious offences, but it's pretty risky, that, isn't it? It could lead to more wrongful convictions, and nobody would want to see people put in prison for crimes they haven't committed. Now we have an AO3 link here as well, and that is that this balance between certainty of guilt and protection of individual rights, this is what's central to justice theory, and it's a little bit like walking a tightrope. Moving on to the codification of criminal law. Codification is a grand idea of gathering all the criminal laws, all the statutes and case law, and putting them into one nice, neat, organised code. So imagine, having everything organised and sorted out into one big book of laws, effectively. Now, England and Wales have a bit of a mixed system. Most criminal law comes from common law. Now, we know that means from cases decided by judges, but there are also important statutory offences like those in the Theft Act, for example. Basically, it's part recipe book and sort of part family tradition. So, advantages of this, well, if we were able to codify law, this would offer clarity, consistency. It would make life a whole lot easier for students and lawyers and anyone who's ever tried to find the law on something obscure, like keeping a pigsty in your garden or something. But there are disadvantages as well. You're going to lose the flexibility of common law. And this common law evolves, you see, because judges respond there and then to new situations as they arrive. So codification is tricky because legal precedents are always changing. This is the thing, isn't it? It's like trying to sort of nail jelly to the wall. Everything's changing all the time. So putting something in a nice, tidy code is pretty unrealistic. Now we have an example here of the Law Commission. Now they have suggested codifying major offences like homicide to make things clearer. But a complete criminal code for England and Wales does at the moment remain a bit of a dream. And at the moment that just doesn't exist. So in terms of evaluation, well, full codification could make the law rigid and slow to adapt. That's one of the problems we've got here. Imagine being stuck with those rules for long periods of time. We also have a reform idea, partial codification maybe, for big offences like homicide. Maybe that could give us the best of both worlds, clarity with a little bit of flexibility. And for AO3 link, well, codification versus judge-made law is a bit of a tug of war between certainty and flexibility. It's a bit of drama there. Moving on to the Crown Prosecution Service. So the CPS is the unsung hero in the criminal justice system of England and Wales. So what is their main job? Well, they review cases that the police send over, and they debate what to do with them. Are they going to prosecute? Are they going to run court cases? Are they going to give police advice as well on evidence and charges? It's a bit like being the manager of a football team, making tough calls and hoping for a win. Now, before charging ahead, the CPS applies a couple of tests. So it applies what it's called the full code test from the CPS code. Now, it's a two-step process, as you can see here. You've got evidential test first of all. Is there enough evidence for a realistic prospect of conviction? If it's all circumstantial, no solid evidence, to be honest, the CPS might just send it back because they won't have any success in court. So that's the first one. Is there enough evidence? Secondly, we have the public interest test. So this is the question of whether prosecuting the case is actually in the public's interest. Sometimes, even if the evidence is solid, it's just not worth the time and money. Like prosecuting someone for pinching a 10p packet of sweets. It just wouldn't be worth it. Now, there are two very important people in the CPS. So first of all, you've got the Attorney General, the AG. Now, this is the government's chief legal advisor who keeps an eye on the CPS and can refer sentences that seem far too lenient to the Court of Appeal for a rethink. Then you've got the Director of Public Prosecutions, the DPP, and this is the CPS head honcho, responsible for making sure the rules are the same across the country, and no regional variations should really be in play. There is one very important cautionary case here, and this is of Stefan Kisko from 1975. It's a very tragic case where mishandled evidence by the CPS led to a really terrible miscarriage of justice. Now, this prompted a lot of reforms and proving that everyone, even legal professionals, can make mistakes. In terms of evaluation then of the CPS, well, the CPS sometimes gets stick for inconsistent decisions and not enough funding, which can mean that cases get dropped or that there are long delays before they come to court. We have a reform idea too. Maybe more funding, greater transparency in decision making could boost public confidence. After all, no one likes a mystery. And then finally, we've got AO3 link, which is the CPS having to constantly juggle public interest with fair trial rights. Again, we've come across this before, haven't we? This is a balancing act, and sometimes, that can prove difficult.